Hello and welcome to Legally Speaking with me, Tarun Nangia. Today, we are going to discuss an issue which is important to almost all listed companies in India, which are listed on the stock market. Also, it regards with compliance and a consultation paper for the proposed review of definition of unpublished price-sensitive information. This consultation paper was floated by Sebi. It is floated to bring in greater clarity and uniformity and compliance of this whole ecosystem. And there are some inputs like the companies would also like to give on this, which will lead to, they say, a better law when inputs are taken far and wide. So in the form of inputs, today we will discuss this issue. I have with me somebody who understands these subjects very well. May I introduce you to Mr. Rajiv Choubey. He's an advocate. He is a group general counsel with Dalmia Bharat Group, a veteran of the field. He's earlier served in big corporates like Vedanta and others. And for the past few years, he's been associated with Dalmia Bharat. Good to see you, Mr. Choubey, and looking forward to some very interesting insights from you on this issue. I have with me Vaibhav Kakkar. He's part and partner with Saraf and Partners, one of India's leading law firms, and a very well-known name on the corporate side. Good to see you, Mr. Kakkar, and looking forward to some interesting insights from you as usual. At the outset, we will go to Mr. Rajiv Choubey, General Counsel, Dalmia Bharat Group, to give an insight on this whole issue concerning the review of the definition of unpublished price-sensitive information. Mr. Choubey, I have a request that in the next 6 minutes or so, 6 to 7 minutes, if you can take us through this whole issue and also share your views on it. Over to you, Mr. Choubey.
Thanks, Tarun, for this opportunity to share my views. One rider, this is not my organization's view. This is, as a professional, we do keep a very close watch on the development which is taking place in corporate laws and securities laws in general, because as a corporate citizen, I think we have to ensure that we are always in compliance with the law. So at the topic which I want to touch upon is the, as you stated, the consultation paper to review the definition of unpublished price sensitive information. And Sebi had also asked for comments, and industry body and chambers of commerce have given their comments, and I'm sure Sebi is actively looking into it. Basically, there is already, the regulation is already in place. And in fact, there was a committee headed by Dr. T.K. Vishwanath, who was the ex-law secretary, and they had, the committee was known as Fair Market Conduct FMC Committee. And the committee had given certain recommendation in 2018, which led to, amendment in the prohibition of insider trading. We call it as PIT regulations. And at that time, the committee had actually recommended that, and there is another regulation, as you may be aware, called the Sebi listing obligation and disclosure requirement. We call it as Sebi LODR, under which there is an onus on every listed entity to declare any material events in accordance with the regulation or the listing agreement. So at that point of time, the committee felt that linking the UPSI, which is unpublished price sensitive information, to material events may not be right, because at many times some of the material events may not be price sensitive information. So it was delinked. Now, after almost, I would say now 5 years, Sebi kind of has proposed, and they must be having right reason for doing so, which I believe. They want to revert back to this definition, wherein any material event which is disclosed by the listed entity under the Sebi LODR regulation 30, that will be deemed to be an unpublished price sensitive information. So that, in my view, and in the view of many such in-house counsel and corporate lawyers and law firms, will actually increase the the burden of compliance, because at one hand, I think we want ease of doing business, and compliance should not become a pain in for any professional or any corporate, or at the same time we want compliance to be done. In my view, and the current definition, which is an inclusive definition, is very wide enough to cover any information which is directly or indirectly has an impact on the share price, right? And there is already a system of structural database wherein the compliance officer has to maintain a list of such price sensitive information with date and time stamp. I think, in my view, what I could guess is that Sebi, for any possible breach of insider trading regulation, wants to rely on the company's database, that what all has been disclosed as part of the structural database, and if certain event has been declared as part of the structural database as a insider trading information, as a price sensitive information, then in case the insider have breached the law, because the general law, Tarun, is that if you are an insider and if you are in possession of an unpublished price sensitive information, you cannot deal in the securities of the company. They are subject to few exceptions, like ESOPs, or you have other exemptions are there if it is inter se between the insiders, or if it is off market transaction. There are some exemptions. So I think the current definition is good enough to cover the concern, and especially taking this along with the structural database. So because see, we have to also understand the practical aspect of ensuring a compliance. A large corporate like, say, L&T or a Reliance Industry, which has multiple businesses, and they are huge corporations whose turnover runs into more than 1 lakh crores or more than 50,000 crores. And so for them to, and now that they have linked the definition to material events, for a compliance officer to sit and calculate whether this order or this event is more than 2% of my turnover, or 2% of my net worth, or 5% of my average net profits, will become a very tedious task. And just imagine the number of people who are working on, whether on the sales side or on the deal side, and to making them understand, So I think the judgment should be left on the company. And I think there are enough, checks and controls, or regulations in place which can take care of that. So I think I will stop here. I think this is the debate which we are, doing it, and the whole purpose is that compliance should be something which is practically doable. So over to you, Tarun, and we can take it forward further.
In fact, the endeavor and the intention of the government is also that compliances should be lesser. The government has constantly been talking about the theme that you trust the companies to do better. You trust the company, reduce the compliance ratio, and then empower the companies or trust them. Of course, you have to keep your checks, but over compliance is, in fact, this government also removed so many laws which were archaic and unnecessary. So I think that's been the theme, and in keeping that theme in mind, let us take this question to Vaibhav Kakkar, partner with Saraf and Partners, who deals extensively with the corporate law. Vaibhav, in your own experience, you've seen this issue from the inception. Could you take us through this whole theme in the next 6-7 minutes and put a point of view as you understand it?
Sure. Thanks, Arun. Always a pleasure to be on your show. Thank you for having me over. I think to begin with, I wholeheartedly agree with what Mr. Choubey is talking about. I think for the benefit of the viewers as well, just to clarify, for a very different purpose under the Sebi listing regulations, listed companies are required to disclose a bunch of events that they regard as material events to the market. Not every material event is meant to be price sensitive in nature. That's what Mr. Choubey was talking about. For instance, shutting down of a production plant could potentially be price sensitive. But in the same breath, corporate actions such as, split of shares, or for that matter, calling of shareholders meeting, all of that is anyways disclosed to the market at large as part of your overall compliances. Now, those are technically material events, but may not necessarily be price sensitive. Now, Sebi had realized that they had painted everything with the same brush by regarding all material events as price sensitive in the past. Sebi corrected that mistake, but now is again talking of bringing it back. Because their logic is that while every listed company is under an obligation to make all disclosures about material information on a real-time basis, they don't do so. And people try and take advantage. And therefore, now again amend the definition of unpublished price sensitive information to include all material information, which the stock exchange is required to be reported to by every listed company. Now, the reality of this all is that what the SEBI ought to have done is that if companies are not discharging their obligation of reporting material events in timely manner, if they are omitting making proper disclosures to the market, that is a separate issue, and that ought to be dealt with separately. Perhaps they need to have tighter mechanisms. Perhaps they need to do stricter enforcement of that rule. But to say that because listed companies do not disclose those material events in time, and sometimes that does result in price speculation, that's what they've talked about in the consultation paper. Therefore, saying that let's bring back all of material information as unpublished price sensitive information. Firstly, to my mind, that would be completely inappropriate for the reason that it is a fact that many of the events that the SEBI is outlined as material events, they are not necessarily all are not in the nature of price sensitive information. For instance, events such as shutting down of say the particular plant for certain environmental reasons could in certain scenarios become price sensitive information. But say discontinuation of a share transfer agent when the investor meet is happening. Now, the moment you regard all of this as price sensitive information, that sort of leads to confusion where then somebody like Mr. Choubey as a compliance officer will now need, as general counsel, will now need to have a trading window shut down each time there is a material event. Over and above that, SDD data, SDD tool that every listed company is now required to have, structured digital database where all information has to be mandatorily stored on a local server, cannot be an outsourced server. All of that information will now need to be percolated right from below. So with regard to every plant, every operation, every revenue number, that will all feed into UPSI. It was not necessary. SEBI could have easily fixed it by being stricter that every listed company is required to disclose all material events to public at large, because that has a very different purpose. The purpose of SEBI mandating listed companies to disclose all kind of material information is that every listed company might have millions of shareholders. Now, they have equity in the company. Now, how do they keep themselves abreast of what all is transpiring in the company? That is the objective with which material events need to be told to the market. But to conflate that with price sensitive information, I think would be again a mistake, with all due respect to SEBI, and will now increase the compliance burden to a level which is unsustainable. And so therefore, I would really hope that through this process of consultation, sense prevails, and we look at alternative ways to get companies to disclose material information quickly and more efficiently, rather than attacking it the other way around by calling every material information as price sensitive information.
Thanks for taking us through this whole thing in detail, Vaibhav. For the understanding of a larger audience who works in various companies, what does this mean? I'll go to Rajiv Choubey from General Counsel Dalmia Bharat. Rajiv, I want one input from you. Could you share? There are thousands and thousands of news outlets in India. India is such a big country that each of them has a big following. in a certain segment. For example, a certain media setup is very big in Lucknow, somebody is big in Kanpur, some other setup will be big in Agra, some will be big in Dharwad, in Belgaum. In India, it is there. Is the responsibility of the company to respond to news by these thousands of outlets? And what does that mean for compliance? Smaller companies would not even be able to bear the cost, because in the end, this is liable for all listed companies, isn't it? Uh, what is the risk we run here by such a thought?
No, I think as far as communication to the stock exchange is covered, I think it is regulated by the LODR, and there is a regulation 30 which says, as Vaibhav was touching upon, that all material events. Now, the law has been amended very recently to define certain thresholds. Say, for example, the threshold is 2% of the consolidated turnover, or 2% of your net worth, or 5% of the average net profits. Now, I will touching upon the point which Vaibhav just said. Let's take an example of a cement company which has applied for a bid for winning a mineral auction. Now you have been just declared as a preferred bidder, right? And then there is a procedure under the mineral auction rules that after preferred, you have to, complete certain milestones in terms of giving bank guarantee and depositing 10% of the mineral value. Then you will be declared as a successful bidder. And then finally, there are other compliances before the mining lease is executed. Now, mining lease is a very, very important, aspect for any, mineral-based company, because unless you have the raw material, you cannot expand, or you cannot even support your current operation. Point is, how do I calculate, going by this example, because there is an X value to this entire mineral over the life of the mineral, say 30 years, 40 years. Now, if a company is having, say, 25 limestone mines, if it gets one more, whether it is material, not material. So I think, this judgment should be left to the company to decide. Company means, I think the code of conduct says that you need to have a committee of maybe, officials, which may be the company secretary, the compliance officer, the CFO or CEO or whatever, based upon the internal policy. So I think, putting this objective criteria to putting the entire material events in a very straitjacket formula, in my view, may or may not work, and then linking it with, the topic which we are trying to, touch upon, unpublished price sensitive information, will become burdensome in my view. And to your specific points, you were saying that there are so many media. So unless any news related to the company is not, material, if suppose going by the example which Vaibhav gave, suppose there is a shutdown, or there is a strike, or there is a lockout, and the lockout is in some Andhra plant, which national media may not have captured, but the local media may have captured. If it has an impact, if the plant is such a big plant that it is contributing to say 20 to 25% of the turnover or profit, then it may become material, and then you need to disclose, that yes, there is some kind of issue which may hamper the production, and hence your turnover, and hence your profit. It then becomes may or may not become a material event. So I think it will all depend upon the facts and circumstances, because, we also have to be very conscious that if I disclose something unnecessarily, which may lead to negative news and the script falling, that is also not a responsible disclosure. Yes. So how much impact, whether it has impact on the operations, because some person may think, oh, this plant has got closed, So it may negatively impact, whereas it may not be the most profitable plant, or it may be the most profitable plant contributing to the revenue. So I think that judgment should be left to the company to decide what is material, not material. And I think already, under the schedule to the LODR, there are certain criteria where you don't have to apply your mind. It is compulsory that you have to, disclose. But there are certain matters on which the company has to decide the, materiality.
I want to understand from you this, that when specific news comes out, for example, a company is wanting or scouting another company for takeover. Now, we know promoters in India who do this all the year. They meet tens of companies, then they decide against a takeover. Because many times these takeovers are not even big. It will be a plant worth only 100 crore or 80 crore or 70 crore. It's not necessary that takeovers are big. Promoters are constantly on the lookout for opportunities.
Absolutely.
Does it mean that they would continuously go on disclosing, and many times certain news comes out in a certain city and dies its own death because it is not relevant to national media? Does it mean that by responding you will take every news national? Because a news many times, for example, I'll give you an example. Take the example of coal mining companies. Many times news appears in Odisha and it is not taken note of or followed, and it dies its own death. Or in Chhattisgarh, for example, it could be the quality of the coal or grade slippage of coal. It could be any issue. But these issues mainly die their own death in their own cities. It are reported in such small lines that nobody takes note, or maybe a few people who closely read every news in town, they take note. Now, if you respond to all of this and everything is to be responded, then means you are basically increasing the scope of each news as a national news. How would you look at this?
No, so as going by the example which you gave, that corporate or the promoter or the senior management, as part of their growth plan, they always scout for assets. And I generally give an example that a boy or a girl wants to get married and he is looking for a match. Now, it's not necessary the first match may conclude into an engagement and a marriage.
Yes.
It may take 5, the boy may like the girl, but the girl may not like the boy. So the point I'm trying to drive is that in any deal, there are so many things, valuation and so on. And, so unless the deal is sealed and signed in terms of any kind of term sheet, or at least a paper to say, yes, these are the contours of the deal, I think you cannot go and announce, because that will lead to more speculation. And I think the objective of disclosure is that there should not be any speculation. And, and this is a hard fact, that whenever you are discussing any potential M&A transaction, depending upon the deal size, there are so many intermediaries involved. There may be lawyers. I know I may engage Vaibhav to do a basic term sheet. So I have to go and give him some basics. Now, Vaibhav's firms will sign an NDA or engagement letter, which will cover him as an insider or a connected person. Right. So the point is, I may go to an investment banker to arrange funds. Again, I may sign some kind of, non-disclosure agreement. It may be possible, it may not be possible, because unless the investment banker, comes on board, I cannot sign any deal. So you go for scouting for funds. Suppose you need $5 billion. So you may contact multiple people to do the funding. So I think, and at this stage, you cannot go and disclose. So I think unless, responding to your point, unless you have actually, done some preliminary kind of agreement, and then it becomes that, sometimes because of some discussions, information does leaks into the media, and they pick up and they publish. And the norm has been the stock exchange always seeks a clarification. So depending upon the stage where we are, the company generally disclose that
Point.
organic and inorganic growth is part of the plan. We keep scouting for opportunities, but at this point, we
That's
confirm
that's
that's the
that,
standard.
that
You
that's
can't
that's a
say
fair.
no. I'm talking to 4 people, and the deal is likely to get concluded. This will lead to more speculation. So I think
That's a very,
uh,
very important point you made. I'll take this exact point to Vaibhav Kakkar, partner from Sarafan Partners, for his input on what just Mr. Choubey said. Do you have any take?
Yeah, absolutely. I totally agree with what Mr. Choubey is saying. Just at the very outset, for benefit of your audience, the earlier point that we were talking about, which is the possible amendment of UPSI to also include material events as disclosed under the listing regulations, is merely at the consultation stage. On the other hand, what has also happened is that Sebi has actually amended the listing regulations about a couple of weeks back, and these rules will come into force from next month. Now,
Okay.
as part of these amendments, one very significant change that SEBI has introduced is that with effect from October of 2023, top 100 listed companies, and with effect from April of next year, top 200 listed companies are expected to look at mainstream media, and they have a pretty broad definition of what mainstream media would constitute. And they've said is, if mainstream media is covering any news that may be of material nature, and there is any news about you as a listed company, then you as a listed company are required to respond by either way of a denial or a clarification or a confirmation about that rumor within 24 hours and tell the public at large. Now, Tarun, at a very sort of high level, if you look at the overall macro picture, SEBI's objectives when they've introduced all of these changes in the LODR regulations 2 weeks back would have been a laudable one. To improve the standards of transparency, to enhance governance, to put up higher pedestal of approval requirements, and to basically ensure that the spirit of accountability goes up. However, I apprehend that somewhere, the pendulum might be swinging too much on another side of the extreme. And maybe I think we are casting the net too large. To give you perspective, for instance, in the US, even in the UK, this is not the standard. A listed company cannot be expected to keep a tab of all sorts of market rumors and speculations that are going on, which may be of material nature, and then have to come up with a clarification or a
within 24
denial
hours.
within 24 hours. Now, imagine if Mr. Choubey is in an advanced stage of a deal, and there has been some media leak. As Mr. Choubey was saying, there are so many parties involved whenever there's an M&A transaction. A media report comes out. Now, the listed company will now be required within 24 hours either to confirm or deny whether the deal is happening. Now, the deal may not have even reached the stage of certainty or finality. You may actually end up disadvantaging third parties, or rather advantaging third parties at the disadvantage of the listed company by leaking very confidential information by giving a confirmation or denial. See, today listed companies usually follow very standard practice where if there is a media leak about a potential transaction, typically all companies have very strong media policies that they don't resort to market speculation. Anyway,
Yes.
SEBI law mandates that whenever a decision is taken, a definitive decision regarding an M&A or any kind of a big commercial transaction, anyways, the market is to be mandatedly informed. And sometimes if there is a media rumor, under the framework of SEBI laws, stock exchanges would routinely put queries to the company saying, listen, there is a media article about so-and-so strike that has happened by certain employees in your company. Please clarify as to what is exactly happened. So, and that clarification would then be disseminated on the website of the stock exchange. But now to say that a listed company will now have to look at all mainstream media, identify any major media speculation, then respond, clarify, or deny to that news within 24 hours, I think is a standard which is extremely high, excessive, quite unprecedented. Even in the US, the obligation of the company to clarify on a media speculation is only when the information is emerging from themselves. So if a company may have come up with a disclosure and it has created media speculation and media rife, then the company is under an obligation to disclose and clarify that, look, what we meant was A, B, C, D, and there's been a misinterpretation of our position. But neither in US nor in UK, there's a mandatory obligation that you identify third-party sources of media speculation and now then either clarify. And as Mr. Choubey was rightly saying, by at that stage where information may not have attained the stage of finality, any disclosure may actually create more confusion amongst the investor community of whether certain deals are happening, whether a commercial arrangement is happening. So this, I feel, I understand the very laudable objective of SEBI. And ultimately, as a regulator, their job is hardly enviable because they need to set a high standard. But somewhere I feel that it's important to strike a balance. Ease of doing business is a very important mantra and objective of the current government led by Honorable Prime Minister Modi, and the regulators also have again and again echoed that sentiment. But at the same time, they also need to enhance governance standards. Somewhere marrying those two twin objectives sometimes leads to confusion, and I think this is one classic example where perhaps the net has been cast too wide.
Point very well taken. I'll take this to Rajiv Choubey from Dalmia Bharat General Counsel. Mr. Choubey, two things here. A promoter and the top leadership is in negotiations. If they respond, they are interested in going ahead. The negotiations may be difficult to even proceed with, because any negotiation
it will amount to gun jumping.
Yes, and it needs uncertainty.
And the moment you confirm, your deadline for a competition law compliance also gets triggered.
And what if you walk out later? Then you jeopardize all the shareholders, because if you walk out after, because maybe, let's take a hypothetical situation where you confirm that you want to go ahead. The other party jacks up the price knowing that this person is now interested because they have not closed. Then you walk out, which means then
unless you sign on the white paper with a black ink, then only the deal is seized. Because if there are more than one suitors, as you rightly told, if the deal may not get concluded. And typically in any good asset, there are more than one, potential buyers.
So this is not the end of it. We will revisit this issue and do one more show on it in about a month's time, because the final word is not out on this issue as yet, even from SEBI. But before we end the show today, we have very little time left. We'll quickly take closing comments from both our panelists. Vaibhav Kakkar from Saraf & Partners, your closing comment, please.
Yeah. No, thanks, Tarun. I think, look, SEBI, as I mentioned, has come up with a bunch of changes last week. Many of those changes are quite critical, quite fundamental. I think they were aimed with the objective of strengthening governance, enhancing accountability and transparency. But somewhere it has had unintended consequences. One of that example was what I just spoke about. There are quite a few other changes that SEBI has introduced. For instance, today, a listed company, if it wants to sell a business through a business transfer agreement or a slump sale, you only required approval of the shareholders if it met certain thresholds, at most, and perhaps a special resolution. Today, SEBI has now introduced a change that you will now, if you're wanting to sell your business through a slump sale, you also require majority of minority. Now, Tarun, majority of minority as a rule, generally under SEBI rules for getting a shareholder vote is normally for related party transactions. Now, to cover even non-related party transactions, independent third-party transactions, and to say every slump sale will not only require a special resolution of the shareholders, but a majority of minority, is again increasing the compliance cost for listed companies.
Not only, Vaibhav, if I may add, it's like minority running the show. Correct. So it is only the minority or the non-promoter who has interest in the company. The promoter has, whatever the promoter is doing is not in the interest of.
Correct. Absolutely.
That's...
Somewhere, Tarun, we will love to sort of spend some time and walk you through all other changes and perhaps in your next episode or what SEBI has done. But I think the critical point really is that SEBI, my apprehension is, as a regulator, they look at bad eggs, they look at bad examples. And in order to make sure that those bad examples are not repeated, they sometimes end up tightening the rules almost too excessive. Whereas perhaps the remedy lies in better enforcement rather than tightening the rules that much more, because then the hurt is felt by all your good governed corporate India, which is actually doing a great job, and the economy is growing at a particular pace. You want to enable the corporates to grow, cannot paint everybody with the same brush and use one bad example to then come up with rules which are so tight that it makes business difficult. I think that is a key challenge, not an easy one even for the regulator, because remember, if there's a scam and there's a problem, then they will be the first to be blamed. So I understand the predicament they have, but striking that balance is very, very important. And I hope that there is much more engagement with the regulators, where some of these changes are actually consultations happen, but consultations lead to some real movement where dilution happens and there is a back and forth. Somewhere I apprehend that some of these consultations are happening, but those consultations don't really change their mind. So they go ahead with those rules as they deem appropriate. So would love to talk more about some of these critical changes that happened in perhaps your next episode.
Point well taken and got the message. Your final comment, Mr. Rajiv Choubey.
So I think Vaibhav has really touched the point. I think the compliance should be principle-based. Regulation should be principle-based. And I think the regulator should not get into, micromanaging the compliance. You lay down the principles, let the corporate decide whether it is material and not material, basis and objective criteria. But I think if we get into applying such kind of very, very objective criteria, it will become difficult for the company to in the sense it will become very, very challenging. So rather than running the business, it should not happen that we spend a major time of senior management on ensuring, because these are very sensitive issues, and one compliance officer in the company cannot. And please remember the timelines. Some of the timelines are 12 hours, 24 hours,
30 minutes.
To respond, 30 minutes. So compliance should be done in letter and spirit, but it should not become a burden. So I hope, our regulator is doing a great job. I think today Sebi is one of the most dynamic regulator, I would say, which has responded to various intervention, which has led to the development of the security market. From what I saw, starting from 1992 now to 2023. But I think at the same time, corporate should be given enough breathing space. And as Vaibhav told, you improve you become stricter in terms of taking actions wherever there is a violation. And I think the principle of comply or explain, that should be the driving force in my
point. Very well taken. So with this, the final word is not out as we'll revisit this issue in a month's time, but
yes.
It was a pleasure talking to you, Mr. Rajiv Choubey, Dalmia Bharat, Vaibhav Kakkar, partner with Sarafin Partners. You brought in your insight on the subject, explained us, took us through all the possibilities of this consultation paper, already what measures have been taken, what is very good for India, also shared with us about compliances and how the India growth story can keep chugging along fast. For that, what needs to be done? Appreciate your joining us and sharing all your insights. Looking forward for more from you both next month. Thank you so very much. And thank you, viewers, for tuning in. Thank you so very much.
Thanks, Tarun.
Thanks, Tarun. Always a pleasure. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.